Good afternoon and good morning, and welcome to the Commercial and Business Litigation Committee's roundtable on M&A disputes in the wake of the COVID-19 pandemic, hosted by the American Bar Association's Commercial and Business Litigation Committee. Today's event is being co-sponsored by the M&A Litigation and Delaware Law subcommittees. My name is Stephen Brown-Okruhlik. I'm a co-chair of the M&A Litigation Subcommittee and a litigation partner at McMillan LLP in Toronto, Ontario. It's my pleasure to introduce today's panelists. Sylvia Simson is a shareholder at Greenberg Traurig in New York. She has a broad commercial litigation practice and, among other things, helps clients navigate contentious, high-value contract disputes, including those arising from M&A transactions and other deals. She's bravely joining us today despite having a court appearance in just under an hour, so we're going to be sure to let her go with plenty of time to log into court. Professor Robert T. Miller is the F. Arnold Daum Chair in Corporate Finance and Law at the University of Iowa College of Law. He's also a fellow at the Classical Liberal Institute at NYU's Law School and is a co-director of the Institute's program on organizations, business, markets. He's written a number of significant articles on material adverse effect clauses and has been cited in many of the seminal busted deal court decisions, including many of those that we're going to be discussing today. Thank you both for joining us. Sylvia, to begin, why don't you help us set the stage? What is an MAE clause and what role does it play in an M&A transaction?
Happy to speak to that. So generally speaking, in the M&A context, an MAE provision or material adverse effect provision, it's a highly negotiated contractual provision that relates to the certainty of deal closing. So the contention of a buyer that an MAE has occurred that excuses proceeding with the transaction can hamper whether or not the deal is actually consummated. It's often described as an allocation of risk or bargained for allocation of risk between the buyer and the seller relating to what happens if an adverse event or a change affects the company that's being bought between execution of the agreement and the closing, so post-signing. And the specific language and scope of what will constitute an MAE will obviously vary based on the agreement and what the parties negotiated. Generally speaking, however, it'll be defined as an event or a change that is or could reasonably be expected to be materially adverse to the business being acquired. And we'll talk about this in some detail today, but generally the parties will negotiate exceptions or carve-outs, and then they will negotiate exclusions or exceptions to exceptions within that provision.
Okay, that's helpful, thank you. Historically, MAE clauses were rarely invoked and frankly not that much discussed. But following the COVID-19 pandemic, they've received a lot more attention. Can you help us understand why that's the case?
Sure. So COVID-19 pandemic was obviously a challenging time for many businesses and affected many day-to-day operations, but also financial performance. And so in light of the pandemic, we saw buyers claim that an MAE had impacted the company they had contracted to acquire, and necessarily this provided grounds for relieving them from actually closing with the deal. Sometimes this was coupled with other allegations, like a failure to operate in the ordinary course of business. But we saw that an influx of that and a lot of people commenting on that during the course of the pandemic.
Thank you. Professor Miller, that sounds like a simple enough concept, the MAE clause, but in fact, they often run over multiple pages in a merger agreement. Can you help us understand their structure and how they work to allocate risk? If that's
sure. So as Sylvia said, that the basic structure of the clause says that a capitalized material adverse effect shall be an event, change, fact, circumstance, which I'm going to now abbreviate as event, that has or would reasonably be expected to have a lowercase material adverse effect on the company, and sometimes this continues, its financial condition or results of operations, followed by certain exceptions and then exceptions from exceptions, but we'll get to the exceptions later. Just looking at the definition as the main part of the definition, a capitalized material adverse effect is an event that has or would reasonably be expected to have a lowercase material adverse effect. Shows you that there are really two things at issue here. There's the event, which is the capitalized material adverse effect, and then there's the effect on the company, which is the lowercase material adverse effect. So between signing and closing, the event could occur that has or would reasonably in the future be expected to have the lowercase material adverse effect on the company, which is not yet felt. So there are two things here. There is the event and the effect. And most inconveniently, this means that a capitalized material adverse effect is not a lowercase material adverse effect. On the contrary, a capitalized material adverse effect is an event that has or would reasonably be expected to have a lowercase material adverse effect. Making things very confusing, people use the three-letter abbreviation MAE very indiscriminately, sometimes meaning the event that has the effect, and sometimes meaning the effect that arises from the event. And you will see in just normal discourse of lawyers talking about these things, and occasionally in the opinions of even the Delaware courts, these things sometimes get confused. When people use, for example, the capitalized material adverse effect term to qualify a representation, they probably don't actually mean to do that. If you say, for example, the company is not being sued except for such lawsuits as would not have a capitalized material adverse effect on the company, what you've just said is that the company is not being sued except for such suits as would not have an event that would reasonably be expected to have a material adverse effect on the company. So sometimes, you know, for example, in the KK case, Chancellor McCormick points out that by using the capitalized term, where they really meant the uncapitalized term, people are introducing multiple levels of would reasonably be expected, right? So I'm not being sued except as would not reasonably be expected to have a capitalized MAE turns into I'm not being sued except for suits that would not reasonably be expected to have an event that would reasonably be expected to have an effect. So it's important when you write agreements or when you talk about things or when you litigate them to keep separate in your mind that there are two things. There is the event, which has to have occurred for there to be a capitalized material adverse effect. And then there is the lowercase material adverse effect, which might not have occurred yet, but would reasonably be expected to occur, making the event that has caused it or is expected to cause it a capitalized material adverse effect.
That's a very important distinction, and I would commend to anybody who's involved in one of these disputes to see a couple of your articles where you provide an excellent taxonomy of the clause and sort of separate the capitalized versus uncapitalized meaning of material adverse effect. So thank you for that, Sylvia. Many of the leading MAE cases, I now use that acronym cautiously, they were decided by the Delaware Chancery Court before the pandemic. How did the court approach MAE clauses, specifically the concept of materiality before the outbreak of COVID-19?
Sure. So in kind of answering this question, I think we can start with the Court of Chancery's decision in Re IPB, which is from 2001. This was a post-trial opinion that addressed a demand for specific performance of a merger agreement, which was by IPB, which was a major beef and pork distributor, and who sought to compel a merger between itself and Tyson Foods, who was a major chicken distributor. And Tyson had terminated the contract in March of 2001, and IPB argued that Tyson had no valid reason to terminate. And Tyson argued that its decision to terminate was proper for several reasons, including IPB's disappointing first quarter 2001 performance, and then a multi-million-dollar impairment charge that had been taken in the year 2010K, associated with a business that IPB had previously acquired, saying that that constituted a capitalized material adverse event, which gave Tyson a right to terminate. And in evaluating this argument, the court noted as follows, that a buyer ought to make a strong showing to invoke a material adverse effect exception to its obligation to close. Merger contracts are heavily negotiated and cover a large number of specific risks explicitly. As a result, even where a material adverse effect condition is as broadly written as the one in the merger agreement, that provision is best read as a backstop, protecting the acquirer from the occurrence of unknown events that substantially threaten the overall earnings potential of the target in a durationally significant manner. So a short-term hiccup in earnings should not suffice. Rather, the material adverse effect should be material when viewed from the longer-term perspective of a reasonable acquirer. So the key language there is a durationally significant manner and longer-term perspective of a reasonable acquirer. And ultimately, in this decision, the court said that the question of whether IPB had suffered a material adverse effect was a close one, but it ultimately found that Tyson had not met its burden of persuading the court that IPB had in fact suffered a material adverse effect including because some stock market analyst views showed that while, and I'm quoting here from the decision, while IPB may not be performing as well as it and Tyson had hoped, IPB's business appears to be in sound enough shape to deliver results of operations in line with the company's recent historical performance. So following this decision, subsequent decisions out of the Court of Chancery were reiterating that the burden of proof with respect to an MAE effect is on the party seeking to invoke that provision to excuse contractual performance, so on the buyer seeking to exclude closing. And then that when you're evaluating the magnitude of a decline in the company's performance, you have to look at a commercially reasonable period, so i.e. measured in years rather than months, and looking at it in a durationally significant manner. That's the language from the IPB decision. Another key pre-COVID case to be aware of is the Acorn decision, also out of the Court of Chancery. That was a decision from 2018. And in this kind of case, the court found that the buyer, Fresenius, did meet its burden of establishing that Acorn had suffered a material adverse effect under the parties' merger agreement. This involved a merger agreement where Acorn, which was a specialty generic pharmaceutical company, would be merged into essentially Fresenius, which was a German pharmaceutical company. And here there was a substantial business performance decline in 2017. There were also whistleblower allegations that were detailed at length in the court's opinion in this case, and data integrity issues. Pretty lengthy opinion. But ultimately, the Chancery Court found that Fresenius had made the requisite showing, namely that the financial performance had declined materially since signing, and that the underlying causes were durationally significant. And looking at that, the court was looking at a significant decline on a year-over-year basis in the performance of Acorn, both with respect to revenue and operating income. It looked at a significant decline in EBITDA. I believe there was an 86% number year-over-year decline that was referenced in the court's opinion. And the key language, I think, with respect to durationally significant in the court's opinion is that the turn in performance had, quote, already persisted for a full year and shows no sign of abating. And that's some language that's quoted in subsequent decisions after Acorn comes out. So those are kind of some of the key opinions that came out in the pre-pandemic timeframe out of the Court of Chancery.
Okay, thank you. So a very high standard, but not impossible in some cases. A material adverse effect does in fact happen. And that standard, I think, has traveled a little bit outside of Delaware, including up to where I am in Canada. A couple of recent M&A disputes included a lengthy discussion by the Canadian courts about that standard coming out of the Chancery Court. Thank you very much for that. Professor Miller, you mentioned that the exceptions to an MAE definition are important in the allocation of risk between the parties in a merger agreement. And before the pandemic, how did the courts approach the accepted events?
So there have been a bunch of empirical studies about what types of events get accepted. I did one myself back in 2009. There's an updated version done by Guhan Subramanian and a co-author in Columbia Law Review last year. But basically what you see is that the exceptions come in groups. There's usually a group of exceptions for what are now usually called systematic risks. General changes in the economy, paradigmatically a recession. General changes in financial markets, paradigmatically a stock market crash or a change in interest rates, change in foreign exchange rates. General changes in the industry in which the company operates, as well as general changes in law or GAAP or certain force majeure events. So in other words, events that would be beyond anybody's control and that would tend to affect not just this particular company, but either all companies, generally a recession, or at least all companies in the industry for the changes in industry exception. Then there's a class of exceptions that are sometimes called indicator risks. So there'll be an exception, often an exception that says any change in the ratings of the company's debt by Moody's or some other rating service, a change in its stock price or trading volume and so on, will not be by itself a material adverse effect, a capitalized material adverse effect, although the underlying cause of any such event may be a material adverse effect. And the theory here is that the parties are agreeing, as it were, not to outsource the judgment of whether there was a capitalized MAE to the stock market or Moody's or S&P and so on, right? They're going to look through to the underlying cause of that indication or evidence of change in value of the company and ask whether that underlying cause really did have a material adverse effect on the value of the company. Then there's a class of common exceptions for what are called agreement risks, changes arising from the fact that the company entered into the agreement, its public announcement, the identity of the parties involved, any actions taken pursuant to the agreement or with the permission of the acquirer, right, can't turn into material adverse effects as well. So then the question becomes, after all those things are accepted, meaning that if one of those things happens, the risk is on the acquirer would still have to close if such an event occurred, even if it had a lowercase material adverse effect on the company. If all those risks are shifted to the acquirer, what's left? And the answer is what's generally called business risks, things largely peculiar to the company itself. So if, as in the Acorn case, it turns out that this particular company has immense data integrity issues, and its chief of compliance has gone off and lied to the FDA, and so that's an event peculiar to this company, it wouldn't fall into any exception under the under a standard MAE definition. Similarly, in the Acorn case, there was a generic drug manufacturer, and between signing and closing, unfortunately for it, several other generic drug manufacturers entered its markets, competing directly against the generic drugs it produced. This resulted, as you would expect, in a sharp drop in the prices for those drugs. And that was peculiar to this company. That didn't happen to all generic drug manufacturers. It just happened pretty much to this one. So that wasn't an industry-wide effect. That was an effect peculiar to this company. I should be saying an event peculiar to this company, and therefore didn't fall into an MAE exception. So the usual classification of risks is systematic, indicator risks, agreement risks, and business risks. And that terminology was adopted. I wrote it 10 years ago, but it was adopted by the Court of Chancery in the Acorn case. So it's sort of become a little more widely known after that.
That's great. Sylvia, in the aftermath of the pandemic, we saw a lot of deals terminated and a wave of MAE disputes launched in the courts. A few of those have now been adjudicated. What are the significant cases, and have courts found the pandemic to be an MAE or one of its effects?
Sure. So generally speaking, the COVID pandemic has not just been viewed as de facto across the board MAE. Put differently, it hasn't been deemed kind of a singular event that merits a different approach than the traditional MAE analysis. The first case that I think is worth a mention is AV Stable versus Maps Hotels and Resorts 1 that was decided in November 2020 following an expedited trial held in August of 2020. That decision granted judgment for the buyer and refused to compel specific performance or enforcement of the sale agreement, and then the Delaware Court of Chancery affirmed that decision. Just by way of background, that AV Stable concerned a sale and purchase agreement for member interests in Strategic, which in turn owns all of the member interests in 15 LLCs, each of which owned a luxury hotel. And that agreement was signed before the pandemic, and the scheduled closing date was shortly after the pandemic began. Among other arguments, the buyer argued that the business of Strategic and its subsidiaries had suffered a capitalized material adverse effect due to the onset of COVID, ultimately relieving it of the obligation to close. And the parties obviously argued at length about whether the effect of the pandemic was material and adverse. In this decision, the court found that it's more, I'm quoting from the decision here, it is more straightforward to determine whether the effect was attributable to a cause that fell within one of the exceptions that was outlined in the parties' agreement, and then looked to the 4 exceptions in the contract that were relied upon by the seller, none of which used the word pandemic, including an exception for, quote, natural disasters or calamities. And the court ultimately found that looking at dictionary definitions, vernacular, plain reading, the exception for calamities encompassed the effects that resulted from the COVID-19 pandemic. And the court looked at the MAE definition content and found that it too supported allocating the risk of the pandemic to the buyer. The court ultimately found for the buyer on other reasons. However, it did not find an MAE based on COVID. Another decision shortly thereafter is Snowfips versus Cake. I think that Professor Miller might have already mentioned that decision today. That was decided in April of 2021 following, again, a trial. This decision involved an acquisition agreement relating to a cake decorating company and cake technology company, DecoPack, which was owned by a PE firm. And the buyer advised that it would not proceed with the closing in April of 2020, and then there was litigation that followed just a couple of days later. In this case, the court kind of noted that, and I'm quoting here again from the decision, the complicated contractual scheme calls for a 3-part burden allocation, and notes that there's the initial burden of proof on the buyer proving that an event had occurred or reasonably would be expected to have a lowercase material adverse effect on DecoPack. And then if that burden is then met, then plaintiffs bear the burden of proving that the event fell within the exception, namely that because it arose from or was related to any changes in any laws, rules, regulations, orders, enforcement policies, or any other binding directives issued by any governmental entity after the date hereof. And then if plaintiffs proved that the event fell within the exception, then the buyer bore the burden of demonstrating that the exclusion to the exception applied because the change affected the target company disproportionately relative to other comparable entities operating in the industry. And ultimately, the court found that the buyer didn't satisfy any of these 3 items that I just outlined. But the buyer had relied on sales data during the 5 weeks preceding termination to say that a capitalized material adverse effect would reasonably be expected. And the court noted in its decision that reasonably be expected to is viewed objectively. It went through the year-over-year sales declinations that the buyer had relied upon, as well as a grocery expert and what those opinions had been. And the court disagreed, saying that it was not reasonably expected that the sales decline would ripen into a lowercase material adverse event. And noted that unlike an acorn, there was no projected sustained drop in business performance. I highlighted that language earlier in today's presentation, and that language was highlighted here. And then the court goes on, when you're looking at the exceptions, that arising from or related to is broad language under Delaware law, and that the revenue declines arising from or related to changes in law as a result of the COVID pandemic fell outside the definition of MAE, as they're a listed exception. So regardless of whether COVID-19 prompted those changes in law, they found that it fell within the scope of the exception. And then the court looked to the fact that the MAE exception had an exclusion, again, looking at whether there was a materially disproportionate effect as compared to the industry. And the court found that the buyer did not show that the target company experienced a disproportionate effect relative to comparable entities. So here, unlike an AB stable, the court did not find a ordinary course of business issue. And so there was a different result as far as whether the closing had to occur. And again, based on different facts, right? I think you're probably all seeing from this that whether or not a capitalized MAE is found to occur is highly dependent on the facts in the case. And every agreement is different. The facts are different. The alleged event is going to be different. And ultimately what folks are debating over whether or not there's the effect is going to depend on the facts.
Right. That's very interesting. So the pandemic, definitely not one single answer for every deal. It's going to be very, very fact dependent, very the court's analysis is going to turn a lot on the financial evidence that's led,
That's right.
including by experts. That's really interesting. Another thing you sort of mentioned that I find interesting and important is, of course, the reasonably expects qualifier, because that throws a whole other dimension into the court's analysis. But thank you very much for that. That's great.
If I may, before you get there,
Please.
Further to what Sylvia was just saying, a lot of the Delaware law is really about giving content to the uncapitalized phrase material adverse effect. And as Sylvia mentioned, back in the IBP case, then Vice Chancellor Strine said that it had to be a substantial reduction in earnings power over a durationally significant period. And in all the subsequent cases, the courts will look at, well, how do you measure earnings power? And sometimes they're looking at EPS, and sometimes they're looking at EBITDA. And after Hexion, it seems to, EBITDA seems to be the preferred measure. And then the question is, well, how much does your EBITDA have to go down? And for how long does your EBITDA have to go down in order for the change to be a material adverse effect, in order for the reduction to be both substantial and long enough? I argued for a couple of law review articles, and I think the Delaware Supreme Court agreed with me finally in a footnote in its A.B. Stable opinion when that case was on appeal, that the easier way to think about this is just to ask about the effect on the value of the company, right? If your EBITDA crashes for 1 quarter, that doesn't affect the value of the company. And if your EBITDA goes down just a little for a long time, that doesn't affect the value of the company very much. The value of the company is the present value of its future earnings. And that's why MAEs are inherently forwardly looking, because if you want to know if the value of the company has changed, what you're asking is, has the present value of its future earnings changed, which is inherently forwardly looking. Valuation is always inherently forwardly looking. And Travis Laster says as much in the Acorn case. He says MAEs are inherently forwardly looking. So this argument that often deal lawyers have about whether or not we're going to mention the prospects of the company in defining an MAE is almost rather beside the point, right? We're always going to be looking at future earnings. And the most convincing arguments that got made in IBP, Sylvia alluded to this a minute ago, but it was also true in Hexion and again in Acorn, some of the most probative evidence had to do with industry analyst estimates of future earnings, the consensus projections for next year's EBITDA and the EBITDA for the year after that, and so on, which of course just goes directly into the value of the company. And COVID-19 then provides a really good example, because the COVID-19 pandemic resulted in a gigantic crash in earnings for most companies, right? The most severe recession in American history for 1 quarter, but everything quickly bounced back very quick, very fast. The values of companies were not adversely affected. See the stock market. And therefore, that was not going to be a lowercase material adverse effect, because the impairment of the value of the companies was just not there. Having a horrible quarter or 2 quarters doesn't affect the value of a company. When you do evaluation of a company, it usually turns out that the long-term earnings, things that come in more than 5 years in the future, in a typical discounted cash flow analysis, account for more than 50% of the value of the company. So having a miserable quarter or next quarter is by itself will almost never be a lowercase material adverse effect.
Oh, that's very interesting. It sort of prompted a question. Does that analysis change at all if the purchaser is buying a company for some reason different than the promise of a healthy cash flow? If they're looking for an asset that they think they can fold into their own business?
Great. Yeah, excellent question. The answer, I think, clearly under the case law is no. In Acorn and elsewhere, the Delaware courts have said that a lowercase material adverse effect means the value of the company on a standalone basis to a reasonable acquirer, not the value to this acquirer, not the synergies this acquirer hopes to have, not some idiosyncratic plans this acquirer hopes to have. If you want a rep or a guarantee of that, you need to write something into the agreement other than a material adverse effect. Occasionally, you'll say agreements that will define the material adverse effect more broadly to say any event that would reduce to the acquirer the value of the transactions contemplated by this agreement. Right. That might begin to pick up synergies. That might begin to pick up other things. but just a lowercase material adverse effect is the value of the company on a standalone basis.
Okay. Well, that's an important drafting implication, I suppose, for purchasers who want to protect the value of some specific part of their target. Better, better to address that specifically rather than hope it's caught in the MAE clause.
And as a seller's lawyer, I would never give that because I don't know what the value of my company is to you.
Right.
I would very much resist doing that, but you do see it sometimes.
Okay.
Stephen, piggybacking on something that Professor Miller had said just a moment ago about what's come out of this with respect to durational significance. Another case that might be worth noting just about COVID-19 and how durational significance kind of played into this. There's also the level 4 yoga versus core power yoga case, also out of the Delaware Court of Chancery. In that decision, one of the facts that the court found compelling in finding that it was not reasonable to expect that COVID-19's effects on the target would mature into an MAE, found that there was a management team forecasts about how long the yoga studios would remain closed. And that estimate, I think, was 6 weeks. And the court said, and I'm just looking down at my notes here, the court said it's hardly durationally significant under any measure. So looking at the length of time is going to be important, and how long you're expecting these financial performance issues to go forward.
In Hexion, Vice Chancellor Lamb has a line where he says, durationally significant would normally be measured in years, not months.
Exactly. And so necessarily weeks are not going to be enough.
Yeah.
Right.
Yeah.
Okay, Professor, you touched on this a little bit already, but we've got the MAE definition, the exceptions, and then there are exclusions or exceptions to the exceptions. And you mentioned a few. And one that I think gets a lot of attention is the disproportionality exclusion. And maybe you can say a few words about that.
Sure. So not all the exceptions, but these ones for systematic risks, changes in the economy, the markets, the company law, are often qualified by a disproportionality exclusion, which says that if one of those systematic events occurs, and has or would reasonably be expected to have a lowercase material adverse effect on the company, then to the extent that that material adverse effect, lowercase, is disproportionate on this particular company relative to other companies operating in the same industry, then the disproportionate portion of the material adverse effect may count as an MAE. So what does that mean? In the Barty case and otherwise, the concept goes like this. A systematic event occurs and it reduces this company's EBITDA by 50%, but it reduces the EBITDA of other companies operating in the same industry by 10%. What we do there is we look at the difference. 50% minus 10% is 40%. And we ask whether the 40% reduction in EBITDA, the disproportionate part of the MAE, we ask whether that effect, taken by itself, is sufficiently large to be a lowercase MAE on the company. This is not the easiest thing to do, all right, but you have evaluation experts who did it. There was Dan Fischel was the evaluation expert for Fresenius in the Acorn case, and he did exactly this analysis, comparing how other generic drug makers were affected over the same period. They kind of all went down. The Trump FDA had loosened procedures for generics to enter the market, so a lot of people had effects somewhat similar to those that affected Acorn. And Travis Laster assumed, for the sake of argument, that maybe there had been a systematic industry-wide event, but even if it had, the effect had been disproportionate on Acorn because its EBITDA went down tremendously, and everybody else's EBITDA only went down a little. The exact numbers obviously varied with how you measured EBITDA and over what periods, but the effect, if you looked at just the disproportionate portion of the effect, it alone was great enough to be an MAE. Now, one issue that often comes up with these things is, how do you know who are the other companies in the same industry as you? And you can imagine with lying valuation experts, each side will choose its comparables in a way that produces the conclusion that its litigators want to hear and that its client wants to hear. So what the courts have usually done looking for comparables is the following. They've gone back to the time the deal was made, and they've looked at the financial analyses done by the party's bankers, particularly the acquirer's bankers. And if that banker did a comparable company study to value the target before signing and relied on a certain set of comparables in providing its fairness opinion, then those, the ones that are valued in the same way as the target, are the ones that you should naturally look to when you ask if a certain event has had a material adverse effect on the target. Has it materially adversely affected the value of the target? What companies should you look to? The ones that you would normally look to in valuing the company, doing a comparable company analysis in accordance with accepted principles of corporate finance. So the control set, the control group, if you will, right, is usually going to be whatever companies your banker thought were comparable before the deal started, not the ones he's pulling out of his hat or she's pulling out of her hat, right, when we're going to litigation.
I wonder if that has any effect on the party's behavior when they're crafting the deal. I do remember the case in Acorn, them sort of being hoisted by their own petard because their iBanker had, made projections for exactly the scenario that they were now claiming was an MAE.
Yeah. I mean, look, there is a possibility of strategically choosing your comparables, but frankly, the number of deals that break up over an MAE is so tiny that it's hard to imagine people doing that. It's much more important to get your valuation right and figuring out the price of the company when you buy it or sell it than to worry about this possibility down the road.
Right.
Now, here's an interesting thing about disproportionality exclusions. In the Barty case, the court held that the target had not suffered a lowercase MAE. My guess is I think that was probably a mistake. I think it probably had. There was one company comparable to it, a publicly traded company, that had lost approximately 86% of its market value coming out of the same event that had adversely affected the target, Barty, in the Barty case. But there was a disproportionality exclusion, right? So if you're representing Barty and you want to argue, if you're representing the acquirer and you want to argue, I should be able to get out of this deal, and a systematic event has occurred that's taken down your control group by 86%, right? You would have to argue that my company was affected even worse than that, judge, right? So if the industry as a whole lost 86%, my company must be worthless before I could actually argue that it had suffered a material adverse effect. And that's actually exactly what the valuation expert in this case did argue. They had a banker who came in and argued that the target was literally worthless, which the court thought was absurd, and it was kind of absurd. But why did they do that? They did that because the cause of the reduction in value, the cause of the lowercase MAE, was a systematic event that was accepted from the definition. Their only hope of winning was to show that this systematic event occurred and had a disproportionate effect on the target. But the proportionate portion of the effect was an 85% reduction in value. So the disproportionate portion couldn't be any more than 15% if we reduced all the way down to zero. They were in a very, very tough position because the definition, the exceptions were just so far against them. Though the text of the contract was so far against them, they had to make some rather absurd factual claims like the value of my company was reduced to zero in order to try to get out. And naturally they lost.
Right. Tough case for sure. Sylvia, from a litigator's perspective, what do you think we do with all this? What are some practical takeaways for a purchaser invoking an MAE clause to get out of a deal, or for the vendor who wants to force the deal to close?
Sure. Look, whether a capitalized material adverse event has occurred and whether the relevant provision in a contract is going to permit one to avoid closing on a transaction, that's a complex and a highly fact-specific inquiry. Every case is going to be different. This is not something that can be decided on a quick and early dispositive motion. There's no automatic bright line test right? I think that language is repeated often in Delaware decisions. The MAE analysis is going to require a close examination of the specific agreement between the parties and the MAE provision that they heavily negotiated. What does it say about MAE? What are the exceptions that are listed? What exceptions to exceptions are listed? So closely looking at what the bargain for allocation of risk between these parties is, right? Then it's going to require a close look at the facts and what happened after signing that formed the basis of the capitalized MAE invocation. So going back to what Professor Miller described at the beginning of today's presentation is the event, right? What are the facts relating to the event or events? And then looking closely at the data, the financial numbers, related analyses, whether that be through the form of expert testimony or otherwise. It's a highly fact-specific inquiry, and it's important for parties to know it's going to require intensive discovery, usually on a highly intensive and highly expedited basis. And also keeping in mind for folks that want to invoke an MAE provision that they have the burden of proof, right? The Delaware has made very clear that that's their burden, and carrying that burden is a question of fact. And so necessarily, a lot of these cases are tried. And a lot of the opinions we've been talking about today have followed after expedited trials.
That's great. Thank you very much. I am mindful of your time and the fact that you have to be in court. So I'm going to ask a question to Professor Miller, but please feel free to drop off, and we thank you for your wonderful presentation.
Thank you, Stephen. I have a few more minutes, so I'll stay on for the next question.
Okay, great. Professor Miller, when we scheduled this event, the pandemic was the obvious context for any discussion about a busted MAE deal. However, just over a week ago, Elon Musk reported to terminate his $44 billion deal to acquire Twitter, which has grabbed the world's attention and no doubt kept you busy fielding calls for journalists and so on. Within a couple of days, Twitter issued a claim before the Delaware Chancery Court. So my first question is the Twitter litigation an MAE dispute? Is that how we should think about it? And second, what else do you find interesting about the case?
Well, I love MAEs dearly, but the Twitter Musk litigation is not really primarily an MAE deal or an MAE litigation. If you look at the letter that Skadden, Musk's lawyers, sent to Twitter when they purported to terminate the merger agreement, it's about an 8-page letter. And the first 5.5 pages explain from Musk's point of view what he thinks is a breach of the agreement by Twitter. And surprisingly, from I think the general point of view, it's a breach of the information covenant. Like most merger agreements, the Twitter-Musk deal includes a covenant by Twitter that it will give Musk information he reasonably requests, subject to certain exceptions. And Musk has a long explanation of I requested certain things and they didn't give them to me. And this is a sufficiently serious way as to be a material breach of the agreement, and therefore he's entitled to terminate. After he goes on for 5.5 pages for all that, he says, oh, and by the way, if this information, it's all of course about the fake accounts and bots on the Twitter platform, if this information came out, which he says it hasn't because they haven't given him all the information he thinks he needs. It says, but when it all comes out, it may be a company material adverse effect on Twitter. He doesn't even actually come out and affirmatively say it definitely is. And then he also claims that Twitter breached the ordinary course covenant. So he has 3 arguments, right? Breach of the information covenant, there's an MAE, and then breach of the ordinary course covenant. But to judge from his termination letter and to judge from the complaint that Twitter's filed against him, we haven't seen the answer yet. To judge from that, the showcase argument is a breach of the information covenant, not a material adverse effect. So you would think that perhaps his lawyers at Skadden and now at Quinn Emanuel have figured out that it's a very high hill to climb to show that there was a material adverse effect. And they're not too keen on climbing that hill. They hope to win on a breach of information covenant argument, not probably so much the MAE. They'll make the argument, but it's not the showcase argument.
I see. Okay, so we can expect something exciting, if not a big MAE fight.
Well, I mean, remember, it's all about, bots and fake accounts, right? So let's assume that, it turns out that the fake account number isn't 5%, it's 10%. Musk would have to show that when that comes out, the value of Twitter is reduced by a material amount. Well, MDAUs are important in this business, but being wrong about your MDAUs is nothing like being wrong about your EBITDA. It's nothing like being wrong about your earnings. Yes, it would filter through. Yes, it would have a material adverse effect, but would it reduce the value of the company 20%? The way it did in Acorn before Travis Laster found that it was there was a material adverse effect in that case? I think that's very unlikely, right? A 1% reduction in value of the company, something under 5% reduction in value of the company is almost certainly not a material adverse effect. In the UK, a lowercase MAE usually requires at least a 10% reduction in the value of the company. In Delaware, we have this one data point that 20% is good enough. That comes out of the Acorn case. How much could you get below 20% and still have a lowercase MAE? No one knows for sure, but I would assume that when you got down to under 10, that probably is not a material adverse effect. So you probably need the high teens. And I think it's financially implausible to think that that type of change in Twitter's MDAUs would amount to, a 15% reduction in the value of the company. That's pretty implausible, I think, from a valuation point of view. So that's probably why, well, one reason that Musk and his lawyers are not beating that drum very loudly. The real action in this case in Musk Twitter is going to be on the information covenant, which I got to say, I would never have expected. I've spent a lot of time looking at broken deals. There's the ordinary course covenant, there are failures to get legal opinions, not using the correct level of effort to get an antitrust clearance, people tanking their own financing, but never just, they didn't turn over information, Judge, that they were required to turn over. That's, whatever else you want to say about Elon Musk, he is a unique individual, and he has invented an untried basis for terminating a gigantic deal.
We'll definitely be watching closely, and if we get a great case out of that, we might invite you back to speak about it. I will mention to our audience members, if anybody has any questions, we've got a little bit of time for Q&A. We've lost Sylvia, but please put any questions in the chat box. In the meantime, I'll take the moment to thank very much our two panelists, Sylvia and Professor Miller. That was a terrific discussion. Thank you for being with us. Thank you to everybody who attended, and a special thanks to the ABA staff who made this happen today. We hope everybody in the audience will consider joining our committee if you're not already a member. If you have any ideas for future programming, please feel free to contact us as well. Barring any questions in the chat box, and I don't see any, I suppose that wraps it up. So thank you very much.
Thank you very much for having me, Stephen. I appreciate it.
Take care.